Good afternoon, and welcome to Immigration and Jobs Talk Show, hosted by Higher IT People. We are targeted at bringing educational and informative sessions with experts like immigration attorneys. I have one today. We'll have a quick intro on the attorney as well. And As many of you know, I've been hosting shows since 2008, and took a break after the pandemic. But that I don't want to, for people who are newbies here. My name is Dan Nandan. I'm the president at Hire IT People Inc. We are a staffing company, and today's topic, we will be discussing with Immigration Attorney Prashanth Dubey, who's on the session. I met him on the, internet, where he's been actively helping the community, answering questions on many social platforms. And then we decided to get further and help the community out there. This show is being streamed on LinkedIn, YouTube at Immigration Talk Show. Please subscribe when you have a moment. This is a brand new channel that we created to bring rich content from experts. And Also, it's a hybrid. There is a conference call number. I'm going to display that number in a few minutes. If you have seen the flyer, you can call that number and sit in the conference call queue to ask a question. Press star six and follow the prompts. So the topic today is going to be about the employment based category 1A, EB-1A, extraordinary ability. So we have Prashant Dubey, a prominent immigration attorney with several years of experience in the immigration law. He's based out of Virginia but supports clients nationwide, including federal litigation matters. They were also ranked number 10 on Silicon India's top immigration attorney list. But before we get there, before introduce the attorney, please note any information on this show is just for information, not to be construed as legal advice. And if you need any case specific assistance, you should contact the attorney. He can be reached at info@dubeylawoffice.com. That's info@dubey lawoffice.com. You can also visit them on their website, dubeylawoffice.com. So welcome, Prashant. How you doing?
Good. Thanks, Dan. Happy to be here.
So I would like to, before we bore people with, a lot of commercial type information, I would like to jump right into the topic. But if you can just give a little brief intro on your background and your practice, so we can educate our viewers here.
Yeah, sure. First of all, thank you, Dan, for having me on today's session. Thank you to Hire IT People for hosting me today. Much appreciated. A little bit about myself, outside of just the professional, to make it a little bit personal as well, right? I am an immigration attorney. I was born in India. I lived there till I was about 3 years old. So a lot of people think that doesn't count. But I will say that, we had a very traditional Indian household and upbringing. And I watch a lot of the same Bollywood movies, that sort of thing, listen to the same Bollywood songs. And I watched very closely my parents go through the immigration processes and procedures early on. And so for me, immigration is something that has really shaped my life. It has shaped my family's life. Most recently, my wife went through the consular processing for a green card in India. And I flew into India to attend her interview and all of that, right? So it's definitely played a major role for me throughout the years. And as an immigration attorney, I've been practicing for about 5 years now. And a vast majority of my practice is focused on employment based immigration. So that can be H 1B, L1s, it can be I-140 and perm filings, it can be self-petitions like the EB-1A category that we're going to be talking about today.
Sure.
And in addition to that, I also do family-based immigration as well as what you mentioned, federal immigration litigation for delayed USCIS benefits. And a bulk of my practice focuses on those three areas.
Okay, that's an amazing intro and crisp, so people can understand. Now, before we jump into the topic, you can comment on either YouTube or Facebook if you're watching on one of these platforms. I can take the you can chat actually. I can take the questions right here and display them on the screen. And we also have the conference call number that is displayed on your screen right now. You can join the conference call, jump into QA session, press *6, and in about 15-20 minutes we will open up the lines for the questions to the attorney. But if you're chatting, I will still take as much as we can. So before any delay here, let me jump into the first question here. Um, Now, can you provide a brief overview of the EB1 category itself, and what is the difference between the EB1 employment-based 1, 2, and 3? And but our focus today is going to be on the extraordinary ability. Can you elaborate on these? It's a little confusing for people, especially for the newbies and people
Yeah.
who've been backlogged. Probably they're under EB2 or EB3 hanging in there. And also want to know, is there something, I've been working with one person. He did not even know that he qualifies for the EB1 because he's been a part of the patent process. He had memberships, and he was getting the high remuneration. So can you please elaborate?
Yeah, sure. No, that's a solid place to start, right? What exactly is the EB1 category, right? It's an employment-based petition, right? So within EB1, you have the EB-1A, which is a self-petition for individuals of extraordinary ability, which is for outstanding researchers and professors. And then you have the EB-1C, which is for multinational executives and managers, right? All of these A, B, C categories fall within the EB1 umbrella. As you mentioned, many individuals are familiar with the EB2 and EB3 employment-based categories, right? That is typically where you see employers petitioning for their workers under those two categories. But as we all know, right, EB2 and EB3 really face a significant amount of backlog and a long amount of processing time right now when it comes to achieving that end goal of getting your green card, right? So for EB2, you typically see individuals fall within that category if they have a master's degree, for example. EB3 is for professionals who have significant amount of work experience but may not have the master's level um, educational achievements. Now, what I've seen recently is that because of those long processing times in the EB2 and EB3 categories, a lot of individuals are trying to jump ship to EB1, and rightfully so, because the priority date, as per the final action date in EB1 right now, is January 2017. So anyone that has a priority date prior to that really has the ability to port that priority date into the EB1 category and take advantage of the benefits of not only filing the I-140 application, let's say in premium processing, but once approved, you can also then go ahead and apply for your 485 application package to get the green card. Now, the EB1 is really for those individuals that set themselves apart within the industry, right? The EB-1A, the reason why it's called an extraordinary ability employment-based petition is because it requires you to show and self-petition that you are in fact the top 5, top 10% of individuals within your field. And the government has laid out a set of criteria, 10 criteria, of which you need to meet 3. And we can discuss that. But from a high level, That is what the EB-1 is, and how it kind of interplays with the EB-2 and EB-3.
Okay. And someone's chatting from LinkedIn. Thank you. You said great initiative. Thanks for the the kind and amazing comment. Um, Now, when we were talking, we'll still get back into the visa bulletin or the priority dates. But typically, you've been explaining about people who were born in countries like India and China, correct?
Yes,
The long wait on the EB-2, EB-3, and of course, even Jan 2017 for the EB-1 category, correct?
correct.
Okay. And now, my next question to you, and how does USCIS define the extraordinary ability? And before I ask this question, now you said self-petition. So, what is a self-petition in terms of, you explained for EB-2 and EB-3 categories, there needs to be an employer, but then, can you educate our viewers what is self-petitioning in reference to the EB-1 extraordinary ability?
Yeah. And it requires a lot of people to kind of code switch a little bit when it comes to their immigration processes. Because if you think about it, when it comes to, folks coming on H-1B, L-1, or, filing those employment-based petitions, all of that has been handled by the employer up until now, right? And so a lot of folks are very familiar with, okay, I'm going to send my employer all of the paperwork that they need, and they're going to take care of it. They're working with an attorney, and they're going to file everything. I'll get a decision. The EB-1A, the beauty of it is that you can actually file it on your own. You don't need an employer to actually petition for you on the I-140 application. You are the petitioner for the EB-1A category.
Okay. All right. Herbert on LinkedIn, interested in your services. How do I contact you? I'm not sure if you're interested in the attorney service. I'm assuming so. I'm just going to flash attorney's info on the screen. It's info@dubeylawoffice.com. And I'm going to put this back again. So please, please keep sending those comments. We will continue this discussion on self-petitioning. So, one question here. Now, when they're doing a self-petition, right, do they require an attorney or they can do this on their own?
So you can do it on your own, right? Now, I'm
I need to break you right there. For folks out there, if you are immigration is very complex, do not attempt to do it on your own and get into trouble. And I always used to tell people on the shows, if you're going to a hospital, either see a doctor or a nurse. Don't see another patient. So I do see a lot of people going on forums discussing with other people who are in the same line, who requires a benefit, trying to take an explanation and example from other folks and getting into a lot of trouble. Every case is unique. That's why we have attorneys like Prashanth Dubey. So, be mindful, be extra careful and diligent before you take a chance. There are a lot of videos on YouTube where people have been explaining, hey, this is how you can prepare forms. These are checklists. There are forums, there are blogs, and they're not authorized to give you any legal advice unless you have a case specific contract with the attorney like Prashant. They're not authorized to give you any. Don't go into these people. There are immigration practitioners, consultants. It's very dangerous, because they do not have the license to practice the immigration law. Thank you to cut you there.
Yeah,
Let's back up. Yeah.
no, and a plain answer to the question is yes. A self-petition means you can file it on your own. Now, should you is a completely different question, right? Because there are nuances to the EB-1A process. Nuances like, how do you interpret these 10 criteria? How do you make sure that there are certain buzzwords across your application? A lot of times when I have seen clients who have maybe self-petitioned, and then, when they get a rejection or a denial and then they approach me, I take a look at the paperwork or the application package, and it doesn't have an accompanying EB-1A analysis, right? There's no analysis being done then on those criteria and how you satisfy them, right? That analysis is a 15, 20-page document that really, presents you in the best possible light to a USCIS officer, right? There's certain buzzwords that need to be used in recommendation letters, for example. And sometimes you have clients that don't realize that, oh, I need recommendation letters. You need individuals across the industry, across the companies that you've worked for, to be able to speak to the projects you've done, to be able to speak to how critical you were to those projects, to be able to talk about your original innovative contributions, right? I'm throwing in some buzzwords right now, to those projects, right? So that is a very important component of an EB-1A application package. And without it, you really don't stand a chance, right? So, whether it's me or whether it's another attorney, just make sure you have the right legal advice, the right legal counsel going into this process, because let's say you do it in premium, that's $3,200, right? Just to end up with a denial. And then you're going to approach an attorney anyways, and you're going to again submit a $3,200 USCIS fees, right? So, don't make those mistakes, and definitely make sure that you get educated and you've got the right legal counsel for this process.
Okay. Now, before we jump into my next question, I have someone from LinkedIn. If we have a master's degree, I don't like to break this with questions, but then I thought this is more relevant.
Yeah.
Mr. Subarao, we will definitely get into this concept. We do have, after about 10-15 minutes, I think we'll be jumping into the qualification criteria as well. So we will definitely answer this question. Thank you. Um, excuse me. Now, can you walk us through the application process, including what is this 3 out of 10 rule? Because there are 10 categories, items that are listed on the USCIS website, the regulation of, one must qualify for the 3 out of 10 criteria.
Sure.
So, can you walk us through the process? I think this is where I think a relevant question, somebody has a 15 years of experience. So I think there is a lot of confusion between, people have asked me, I have a PhD, do I get an EB-1? Or I have 25 years of experience in a managerial level, do I get an EB-1A? So can you please elaborate and give us more enlightenment, for me and for the people watching?
Yeah. Yeah. So for me, the process starts even before we talk about the criteria, right? So typically when a client reaches out to me, what I tell them is send me your resume, right? And send me an updated resume. That way, at the very least, at first glance, I can say, hey, it's not worth getting on an assessment call, or a consultation call right now because I don't think you satisfy the criteria. And here's my feedback for you to do so. If I see that, okay, they're going to hit at least 3, maybe 4 of the 10 criteria, then I say, let's get on a consultation call. Let's talk through it. Let's talk through the process. Let's talk through the criteria. Let's talk through your resume, your work experience, the projects you've worked on. And also let's talk about who's going to talk about those projects on your behalf, right? Because the recommendation letters are extremely important. Sometimes you have clients that have really burned their bridges over the years, and you're doing yourself a disservice by doing that, right? Because you sometimes may need to go back to someone that you worked with 5, 10 years ago to write about you for a project that you had a significant impact. You may be with another company now, so you have no access to those internal systems, those internal records, that will help inform and really, substantiate your claim that you worked on this project. So you need to then identify 1 or 2 individuals that can speak on your behalf. So we walk through all of that during that initial assessment, initial call. From there, what I do is I send my clients back with some homework. I say, hey, These are the criteria you've hit, and we'll get into the criteria, but think about the projects you've worked on. Why were they critical? What kind of leadership role did you have in them? What kind of ROI did you have in them? What kind of dollar amount impact to your company, to the industry did you have with them? Um, who are the 1 to 2 individuals that are going to speak on your behalf with regards to these projects, right? So that can be another 1 month exercise where they really need to sit down, elaborate, and think about all of the projects that they've worked on. And you probably want to pick your top 4 to 5 most impactful ones, okay? And then, they come back to me, they send me a 10-page document, and then we hop on another call and we iterate on that document. We talk about, all right, what are the qualifications of these recommenders that you've identified for this project? Can you provide me any architecture diagrams if you're a software professional or engineering professional? What sort of evidence do you have on hand to substantiate your claim that you've actually done this? From there, we finally get to the retainer agreement, right? That's where my clients are, bought in and they feel like, hey, we can move forward with this process. We feel confident, we feel comfortable that, we can potentially get an approval here, right? We don't guarantee an approval, but at the same time, that's why that process is so important, so that if you do need to go back to the drawing board, I will send you back to the drawing board. I'm not going to take a case where I feel, you've maybe got 2 here and we can make a stretch argument for number 3. That's not a good experience for anyone involved, okay? So once that has happened and you've identified the projects, you've identified the recommenders, we embark on an 8 to 12 week process where I then draft the recommendation letters for you. We want to make this process as easy as possible for the recommenders. We don't want them to have to write too much. They're not going to know all the buzzwords or the nuances. There's very specific language that I like to use in these recommendations. And over the course of those 8 to 12 weeks, as we draft the recommendation letters, we get them signed, we complete the EB-1A analysis, right? Based on your profile, based on your resume, your certifications, where you studied, your level of education, all of those details go into the EB-1A analysis. We're finally ready to file. My clients often opt for premium processing because you get a decision back within 15 days, right? So it's very much something that is appealing to them to do it in premium. Now, once, let's say, an approval comes back, then you file the 485 application. The 485 application is your actual ticket to the green card, right? That allows you to adjust your status from within the US. So that's the process in terms of getting from point A to point Z, right? There's a lot that goes on there. Now, with regards to the criteria, there's 10. I would say, where I see my clients who oftentimes come from software engineering, software development backgrounds, where I typically see them fall in is about 4 to 5 very specific criteria. One of them being evidence of your original business contributions to the field, right? So original means innovative. What have you done in the field that is innovative? Did you create a new way to solve a technological problem? Do you have a patent or research to your name that's been cited and adopted across the industry? That is very important when we're talking about an original contribution.
So that brings up a question here in terms of I was actually working with one of our employees. Now the issue was he was a part of the patent process. This was with one company where they developed a prototype, and the patent was, I think, the IP was approved. But however, when the company filed the patent, with a contribution, his name was not listed. So and the USCIS was not willing to take the recommendation letters where the peers or his seniors have written recommendation letters. How do we handle these type of situations? I know this is a lot of paperwork. It's a case by case. In general, How do we handle? How do you handle this type of complexity?
Yeah, I would say if there are records tying you back to that patent, right? Typically, recommendation letters are definitely going to be important. And if you've done that, that's great. But if there are email threads where you've provided your feedback, your insight, your guidance on that prototype that later on went to be patented, that becomes evidence that is really irrefutable, right? It has your name on it, it's tied to you. If there's specific design, architecture diagrams that you've created, work product that you've created around it, that is how you can kind of overcome any challenges that USCIS might pose to you by saying, like, hey, you're not an author on this patent. So, how do we know you actually worked on it? The more evidence you can layer on or to your body of work, to what you've done, the better the chances, the better the shot you're going to have at proving to them that, hey, I did in fact contribute to this patent. I did have an original contribution. I just wasn't as an listed as an author. So I would say you get secondary evidence like emails, any other communications. It can be like, through Teams or Slack channels, for example. I would say any internal work products that you've developed, that you've provided, you can layer on that sort of evidence to really strengthen that criteria.
Okay, we'll take a small break of 30 seconds. I'm trying to, we have a small technical difficulty on YouTube. We'll fix that and come right back. We'll just take about 30 seconds. Yeah, welcome back. We have a small problem with the chatting on YouTube, but I do see a lot of comments. Excuse me, comments coming in from LinkedIn. I promise to fix it by the next show. I think being a new YouTube channel, looks like YouTube has not um, given us the access to the chat feature. But this is also being streamed live. You could go to hire IT people, HIRE IT people, and send in those questions. I do see a lot of questions here, and we will get right in. Now, let's jump into. I do have a lot of questions from participants, but then I have a few more questions on the topic itself, Prashant. Can we? Can you give some notable examples of, in other words, approvals, like a case study? Maybe a
Sure.
small snippet of, most of our viewers, they're from IT background, as I'm assuming there might be people from other backgrounds like sports or athletes or artists as well. But however, any type of example where we have seen a success in the timeline, if it went for premium processing, if there was an RFE, and how long did it take, and how long does it take to first collect all these documents? What is the, the freezing period, or the document collection process versus your due diligence process, and then filing the case, and if there's an RFE. So what are these, specific timelines and the approvals that you've seen?
Yeah, yeah. So the, the timelines, I would say, kind of when we start the consultation process, I send my clients back with that homework to identify, the top 3 to 5 projects that they've worked on, identify the recommenders that they would like to have speak on their behalf and sign off on these recommendation letters. That takes about a month, right? It really takes some time to think through what it is you've worked on, what it is you've done, who's going to speak on your behalf, reaching out to those people and getting their consent where they say, yes, we are ready to, sign off on a recommendation letter, or we're ready to review it, provide our input, and then sign off on it. So that takes about a month. And then from there, it takes about 8 to 12 weeks to draft the recommendation letters, draft the EB-1A analysis, assemble the I-140 application package, and send it off to USCIS. So I would say end to end, you're probably looking at 12 to 16 weeks. This is a very deliberate process. It's also an expensive process, right? So it's not something that you really want to rush through. It's not something where you want to be very haphazard in your approach of, collecting recommendation letters and saying, oh, I've got 6 and, the other 6 haven't responded. No, let's try to get 12, right? Or let's try to get as many as we can. I typically say 8 to 10 recommendations is good. Anything above and beyond that is obviously great, right? It helps if you've got the projects to back it up. We obviously don't want to provide any fluff. Now, with regards to the case studies, I'll talk about a couple folks that I filed for this year that got approvals, right? And I'll speak within the context of the criteria. So as we've mentioned, there are 10 criteria. And I imagine everyone here has probably seen those 10 criteria, right? At some point in their life, you've gone through the USCIS website and you've searched EB-1A, extraordinary ability applicant, right? How do I jump ship from EB-2 to EB-3, that sort of thing. One of my applicants early this year, he's a solutions architect and he's working for the city of Baltimore. The 3 criteria that we really argued for him on was original business related contributions. Okay. So in 2019, there was a ransomware attack that impacted the city of Baltimore. He was the one to actually bring their systems back online, right? That was important, right? Because their department their billing department for water revenue had completely shut down, right? So he had to find really interesting, unique, innovative ways to bring that system back online. On the same basis, we also made an argument that, hey, he had a critical role for the city of Baltimore because this city was losing millions of dollars. I'm talking millions of dollars before he actually brought their systems back online and they were able to start billing people again for their water usage. And then the third criteria, which is a very objective criteria, is he commands a high salary, right? Over $200,000 a year. From an architecture engineering perspective, if we just go to the Bureau of Labor Statistics, you can very easily see that they say, hey, top 10% of earners in this industry, they earn $170,000, $180,000, right? So it's a very objective criteria to be able to satisfy when it comes to salary. So for him, we were able to hit those 3 criteria and get his approval. A second case was most recently for a product manager who works at Comcast. We argued on 4 criteria for him. He actually has a very interesting background in that he's also a CFA holder, right? CFA is a certification that requires about 2,000 hours of studying. And within the financial professional world, it's very difficult to achieve, right? So in addition to the original business contributions that he had at Comcast during the COVID-19 pandemic, when it came to, making sure their systems were set up for, allowing all of this new bandwidth, increase in usage, Comcast had to manage that. They had to make sure that they could absorb that usage, and he was kind of the brains behind it. Another one was evidence of a critical role. Again, around the COVID-19 pandemic, we made an argument around that project of his. He also helped set up a big data platform for Comcast, which had never been done before, right? And they were then allowed to process data 10 times faster than they were previously, right? The third criteria was evidence of a high salary, right? Typically, you need to fall within the top 10% of earners within your industry. So based on other product managers, he was earning over $210,000 a year. Top 10% as per BLS was around 170, 180. Again, very objectively able to meet that criteria. We were able to secure him a fourth criteria, which was membership in associations that require, quite a bit of effort and work from people that are a part of it, which is where him being a CFA really helped. And we just got his approval last week. I'm filing his 485 application this week.
Wonderful, wonderful. We do have a lot of questions here, so we'll take some of these. If somebody's watching on YouTube, the live chat on YouTube is fixed. It's working now. I know this is work time, so a lot of people are just trying to send their comments. It's absolutely fine. You don't have to jump into. I do have some callers, sitting on the call queue on the conference bridge. Now let's take this question from. You'll see it on your screen. This is from Kumar Swami. Can our EB2 priority date be ported to EB-1A? I think he answered this question, but if you can quickly jump into that, Prashanth, to help our participant.
Sure, 100%, right? That is why the EB-1A option is so attractive. A lot of individuals with EB2, EB3 priority dates that predate 2017, right? At least currently. And what we do is we draft a letter. We say, hey, this individual has a previously approved I-140 petition in the EB2 or EB3 category. Here is evidence of that. So we provide the I-140 approval notice. We would like you to port this priority date to this new I-140 application we're filing under the EB-1A category. So it needs to be carefully crafted and approached, but yes, it can absolutely be done.
So I have a follow-up question to this porting of priority dates from one category to another category. Recently, I think a couple of years ago, people were downgrading, upgrading EB2 to EB3. There's a lot of noise out there, but everything settled back. There's a retrogression. Now, this is a general question people have asked multiple times. Can I port my 140, which was filed from a different employer? B, what if the original 140 was withdrawn? Do I still grandfather?
So you're saying, can you port to a new employer?
Yes.
With an old I-140 approval from employer A?
That's correct.
Okay, so you cannot, right? You do need employer B to file a new I-140 petition for you. So
when they file the new 140 petition, can they port the priority date from employer A to employer B? That's the question.
Yeah. Yes, absolutely. Okay. Right. You retain your priority date. Absolutely.
Okay, wonderful. Kumar Swami, that question is answered. Now we have another question here. My wife completed her PhD in nutrition and dietetics in India. Will she be eligible for EB1? I think he explained this pretty well, but then, I think if you can circle a little bit around the PhD concept of, the qualifying criteria, if you can, brush this up a little bit, I think that'll help the viewers much better.
Sure. And, typically, and I would say in the past, right, maybe 10, 15 years ago in the industry, when it came to EB-1A, you would typically only hear that professors and researchers and PhD holders were the one that were getting the EB-1A. And it's because USCIS has very specific criteria around, have you been able to publish materials in major trade publications? Have you done peer reviews, right? Have you had a scholarly impact on your industry? So in order to demonstrate that, what researchers and professors would say, hey, look at my sampling of publications. Look at how many times I've been cited, right? The more citations you have, the more it looks like you've really had that scholarly impact across your industry, and people are looking to your work for guidance and for direction. So that's really important. So, it's not that just because you have a PhD that you would automatically qualify for the EB-1A, but we would need to see your body of work. We would need to see how many publications you have. We would need to see, have you done peer reviews for other journal publications, for other editors, right? Or have you done peer reviews for conference papers? Has your publication been cited, right? You can have 10 publications, but if no one is citing it, then it doesn't look like you really have had much of an impact in the industry. So just something to, to note there. There is a separate set of criteria within those 10 criteria, specifically directed at professors and researchers. But again, we just need to take a look at your application package holistically, see what kind of publications you have. Have you done peer reviews? And how many times have you really been cited or sought after within the industry as an expert?
Okay. Now we have another follow-up question here. They sound a little similar. He has 19 years of experience as an IT manager, and he also has a approved 140 under EB2. Can I just port to EB-1A? I think you've been answering this question, but if you can help Mr. Yaluri a little bit.
Sure. Yeah. You actually have a couple different options, right? EB-1A is obviously one option, right? Again, we would need to take a look at your body of work because an I-140 application and EB-1A analysis does need to be submitted with the application package. So we need to prove that, hey, you actually meet, 3 out of the 10 criteria. And typically where I see those software professionals, QA professionals fall in is original business contributions, critical or leadership role, commanding a high salary. You might even be able to hit another one if you have a membership in an organization that demands outstanding achievements. But those 3 that I mentioned first are typically where I see, my IT professional clients fall in. So if you satisfy that, and if you also satisfy what USCIS has this final merits determination, which says it would be beneficial to the United States for this individual to stay here, to work here, such that we're going to waive, this, prevailing wage determination requirement. We're going to waive this perm requirement. Then yes, you can port to EB-1A. You also have the opportunity, if you're in an executive managerial level capacity, to do EB-1C. But keep in mind with EB-1C, you do need an employer to petition for you. It also requires you to go outside of the United States for 1 year in the preceding 3 years in order to qualify for it. And I've seen clients do that as well, but it's a conversation you need to have with your employer first.
Looks like we do have an upcoming question on the EB-1C as well. But then, I would like to take a call. Before we get there, a small announcement here. If you are looking for a project placement, we can help you find a project. We have direct lines. Please send an email to support@hireitpeople.com. We also sponsor non-immigrant visas like H-1B, TN, and E-3. We are a GSA certified company with National Minority Development Certified as well. You can also call us at 833-412-8472. That's 833 H-1B visa, or log on to hireitpeople.com. Welcome back, Prashanth. Now, I would like to take a caller here. Phone number ending 5732. You're on the air. You can ask a question. Hello? Hello? Phone number ending 5732. Can you hear me?
Yeah, hi Dan, hi Prashanth. This is Ravi.
Hi, Ravi. How you doing?
Hello.
Yes.
Hello.
Prashanth, can you hear Ravi?
I can hear him. Hey, Ravi.
Yeah. Yes. Yeah. Please be a little louder.
Okay, good. Yeah, can you hear me?
Yes.
Yes.
Yes, we can hear you.
Okay. Okay. I'm correct. Okay. Can you hear me now?
Yes, yes.
Okay.
Um, uh, I think looks like we have a technical
Your
difficulty
voice.
here, Ravi.
I can't hear you, Dan or Prashant.
Okay, so if you can go to one of the platforms, YouTube
Hello.
or LinkedIn, and send us a message, comment on the live video, I will take that
I
question. Thank
can't
you.
hear you, Dan.
You can hear me?
I
Hello?
think he said he can't. He can't hear us.
You can't hear us? Okay, I'll have to drop him.
No.
We'll continue with the session. We're sorry. We'll try to. It looks like we have a technical problem here. Since this is a hybrid show, unusual of integrating different applications, the five, 6 different applications that are running together. I think the system's memory is running low. So the next, let's take another from our chats here. Okay, now this is a great question from Dharmpal. Thanks for that question, Dharmpal. Will EB-1A remain intact even if you switch organizations? I think you said, self-petition, but, people are, this is definitely a complex and confusing matter. We definitely need your help and advice. Can you please help with this question, please?
Yeah. So even if your EB2 or EB3 petition has been approved with employer A and you move to employer B, you can still file an I-140 application. You can self-petition an I-140 application in the EB-1A category, even if you're with employer B or employer C or employer D, right? That's the beauty of the EB-1A, is really the flexibility it gives you in that you can file this petition, again, likely with the help of an attorney, but you can self-petition yourself with minimal employer support. And when I say minimal employer support, I say that because you may need recommendation letters from your manager or from peers, that you've worked with, but they don't need to be the ones that sign off on the I-140 application. You as the petitioner are the one that signs off on the I-140 application and that petition. So you can absolutely do that even if you're with a new employer.
Okay, so there's one more question here. Can we file EB-1A from outside the US via consular processing?
Yes. So you can do consular processing for EB-1A. That is not a problem. Essentially, what happens is you still have to file the I-140 application, right? You still need to get approval for the I-140 application. So you're likely going to work with an attorney here in the US. They will file your I-140 application. They will even indicate in that I-140 application that you will not adjust status in the United States. You are instead going to do consular processing, and your application, once it's approved, will go to the National Visa Center. Once a visa becomes available for you, they will send you an interview packet. They will follow up with you on next steps so that you can do consular processing in your home country. So it's absolutely possible, even if you're not within the US physically at a given point.
Okay, thank you. We have another question here, slightly relevant into the EB-1C. I'm on an H-1B and worked with my company offshore for more than 1 year in the preceding last 3 years. Can my organization file EB-1C without converting to L-1A? I'm assuming he's a kind of a multinational manager or something. So can we answer this question, please?
Yeah. So the L1A, it helps, right? Because the L1A says, hey, we're petitioning this individual specifically for a multinational executive or managerial position. I've had clients who get the EB-1C even without an L1A. It's not a prerequisite. Nowhere in the EB-1C criteria or requirements does it say that you absolutely must have an L1A as a prerequisite in order for your employer to file the EB-1C. If you were operating in an executive or managerial capacity, you had hiring and firing decisions, you oversaw a team of individuals, you were doing performance reviews, you were doing interviews. If you fit the profile, even if you come back on an H-1B, you can still file the EB-1C application along with your employer. So keep in mind, for the EB-1C, the employer does need to petition on your behalf. So that is an important conversation that you need to have with them as to how you qualify, right? And how they can petition on your behalf and send that application along the USCIS.
Thank you, Prashanth. I think Hitesh, I hope your question is answered. We have one more. We have 10 more minutes left on the show. We will take a few more questions and continue with the topic. And someone also asked to summarize once again. You can replay this entire video. This is going to sit on YouTube, but we will definitely request Prashanth to summarize the entire concept in about 5 minutes. Now, the next question here. Sakshi Kumari has a PhD in antenna design and have publications too. And what is the minimum peer review and citations requirement for EB-1B?
Yeah, it's a sliding scale, right? So again, even with EB-1B, you do need an employer to petition for you for that specific category. But when you look at peer reviews, when you look at citations, if you have 10 publications that have been cited 800 times, 600 times, 500 times, that's impactful, right? And that's important. And that sounds like it's very critical and that you've had an impact across the industry. If you have fewer citations, you need more publications. And if you have less publications, you need more citations, right? So it's that sliding scale. That's how you want to look at it, and that's how you want to talk to your employer about it in terms of putting forth an argument for an EB-1B application.
That's wonderful. So, the EB-1B is the outstanding researchers, professors, those types?
That is correct.
Okay, so EB-1A, EB-1B, and EB-1C. So except for the EB-1A, the other categories still need an employer to petition.
That is correct.
But can an employer petition for an EB-1A?
No need. It's a self-petition, right? So it's almost, they don't have to.
They don't have to, but they can.
They can, but it's not a requirement, right? The petitioner is, I would say, 99% of the time the client.
Okay. All right, folks. So, we'll quickly summarize the entire process. But then if you think you qualify, it doesn't hurt to get a consultation with the attorney, Prashanth Dubey. You can reach him at info, I-N-F-O, at dubeylawoffice.com. That's D as in David, U as in umbrella, B as in boy, E as in Edward, Y as in yellow. Dubey Law Office, one word.com. And it doesn't really hurt. And, based on the questions people have asked and the amazing explanation by Prashanth, looks like I've come across a lot of people who have something in their background they do not even know that they might petition for. It's all about, we've had a long discussion last hour. It's all about collection documents and getting that professional attorney advice. So once again, don't research too much on forums and WhatsApp groups. I would strongly recommend that you reach out to an attorney like Prashanth Dubey who can help. Send him an email, and you can visit his website as well, which is dubeylawoffice.com, and try to get a consultation and send in your resume and see how it goes. And you can mention High Rating People Show to get a service discount. Now, can we quickly summarize? We have 5 more minutes left on the show. So before we go, I just want to add one more thing. We will be continuing these sessions every Wednesday at 12, and we'll try to fix the phone calls, but I noticed, over the weekends, it bombards with phone calls, but then, people are at work. We wanted to make sure we are able to cater to people who are watching from India, not make it a midnight, 1:30 or 2 in the morning for our viewers out there, our listeners out there in India. So, but then we will come back next Wednesday, every Wednesday at 12 noon with a fresh topic. But if you have more questions about today's show, please comment on the video that is going to sit on YouTube and LinkedIn, wherever you're watching. Or you can also email us support at hireitpeople.com or info at Dubey Law Office, .com. So, he can answer your questions. Now, Prashant, if you can take a few more minutes before we log off for today's session, if you can quickly summarize uh, the entire topic in about, we have 5 minutes.
Yeah, be brief and be gone, right? As they say. So again, today's topic was around the EB-1A employment-based category. Now, within EB-1, there are three subcategories: EB-1A for individuals that have extraordinary ability, EB-1B for outstanding professors and researchers, and EB-1C for multinational executives and managers. In order to qualify for the EB-1A, there are 10 specific criteria. And where I typically see clients fall, especially ones that have a software, IT, or engineering background, is original business contributions, right? So innovative business contributions. Have you done something novel? Have you solved a complex technological problem in a new way or in a new light? Have you achieved any patents? Have you done any research, right? And you'd be surprised at the number of IT professionals that have research in their background, especially if they've done a master's program here within the US. It's almost like they have a line of sight to the EB-1A down the line, In addition to that criteria, I typically see folks have a critical or leadership position within their organization where they can talk about the projects that they've worked on, the ROI that's been delivered, the amount of money that they've helped their organizations achieve or save, right? It works both ways. The third criteria that I typically see is also the commanding a high salary. You want to be in the top 10% of earners in your industry in order to qualify for that criteria. If we're able to get a fourth or a fifth one, right? As I mentioned, there are some IT professionals that have research in their background who have done peer reviews, that sort of thing, then we can always argue on that criteria as well. But those are the top three criteria that I see for my software, my engineering, my QA professionals that come to me and pursue this process. Keep in mind, as a reminder, this is a self-petition. You do not need your employer to petition on your behalf. You can file this application as the petitioner with support from an attorney. Another thing to keep in mind is that you can port your priority date from the EB2 or EB3 categories into any of the EB1 categories, whether it's A, B, or C. So I would say that's, to summarize kind of the major points and to give you the greatest hits on the EB-1A process.
Thank you for that summary, Prashant. But we will take a few more minutes. I do have two more questions. Someone's asking, I think this is a little off the topic, but Krishna, can an Australian citizen? I'm assuming you were born in India, and so remember, being an Australian citizen, I've been reminding people, any green card process goes on country of birth, not based on country of nationality. But his question is, an Australian citizen, am I qualified for a GC lottery?
Okay, so that sounds like they are talking about the diversity visa lottery, right?
Right.
And there are a certain number of countries and specific job codes that if you fall into, that would qualify you. But if you are, let's say, an Indian national, or sorry, born in India and an Australian citizen, you can qualify for the diversity visa lottery as long as you satisfy some of the other requirements. And they're all listed in the State Department website. So feel free to email me. I'm happy to send you those requirements. We can talk about it a little bit further.
Okay, his email is info@dubaylawoffice.com. I think we should talk about the cross-country chargeability and these type of topics in our upcoming sessions for sure, because people have a lot of questions about. My wife is born in, for example, Dubai, and I'm an Indian national, but I was petitioned for EB-2. What happens with this cross-country chargeability regulation? So we will definitely come up with those topics. We also plan to have a complete Q&A session rather than revolving around a certain topic. So keep the session for, thanks, Prashant. He has agreed to be on a session for an hour where we just take questions. But, I see two more questions here. Can an employer help to build criteria for EB-1A eligibility? I don't know, our attorney should be answering this question. As an employer, I can answer this. Yes, employers can help because they are knowledgeable about your process, your background, if you've been working with them for years. And you can, but still, it has to go for an attorney review. Your employer can help you with working with your previous employers, maybe if you authorize them, but then you still have to go for an attorney review. That's what I would suggest. Do you have anything to add on this question, Prashant?
Yeah, I would say, a lot of times folks approach me because their employers and their employer's attorney will say, no, you don't qualify, right? They've got this very, narrow view of who qualifies for the EB-1A. Again, you will require minimal employer support, in the form of, let's say, an employment verification letter or recommendations from peers or managers, at your current employer. So they do play a role in this process. It's just that they're not the ones that are signing off on the I-140 petition. At least they don't have to be, right? So it's a conversation that you will need to have with them at some point. But just know, you own this petition.
Okay. And we have another question, but then Pawan, I think if you can rewind this video, uh, last an hour, because we are at the closing moments right now. But then if you have any follow-up questions on this after you watch this video, just go back to YouTube, Immigration Talk Show. You can also subscribe, YouTube at Immigration Talk Show, or we also have a LinkedIn page specifically for this show. Again, that's Immigration Talk Show as well. You can subscribe or follow, and please play back this video. And if you have anyone has questions, please feel free to email the attorney at info@dubaylawoffice.com, or you can also email us at support@hireitpeople.com. We are, Hire IT People is only hosting this show, and you will have to deal directly with the attorney. We will not be able to help with any legal advice, and you make a case-specific contract or consultation with the attorney. And Prashant, thank you. Thanks for your time today. Let's, come back next week with another hot topic. But before we close this session, one last item here. The recent USCIS update on the field manual update, or the policy guidance, are there any significant changes, or it's just that they wanted to explain this, how people to make them understand the regulations?
Yeah, I think that most of the criteria stayed the same, right? But one that did in fact change quite a bit was reviewing the work of others. In the past, what attorneys like myself would do, we would say that, hey, if you're mentoring your peers, if you are interviewing people, if you're doing design reviews or architecture reviews, for within your organization, that qualifies as reviewing the work of others, right? And I think USCIS over this last year has picked up on that. And so they issued very clear, clarifying guidance saying, that is considered something That is a part of your day-to-day job. That does not mean you're going above and beyond, your normal role and activities when you're reviewing the work of others, right? So they've taken a strict stance on it by saying, hey, this is more for doing peer reviews or reviewing conference papers or reviewing journal publications, or let's say a company reaches out to you for your expertise and they want you to conduct some sort of health check on an application they're migrating to the cloud, right? So it's taken a more industry-wide approach as opposed to you simply mentoring or having direct reports. They're now saying that's part of your day-to-day job. That's where I've really seen a change as per the new guidance.
All right. Thank you, Prashant, for your valuable time, and we will connect again soon next week, same time, 12 p.m. And please follow and subscribe to ensure you will receive these updates. We will also be uploading uh, informational videos. We will record sessions. We're not just going to be live at all the time, but then please subscribe. So we plan to answer the general questions like these because there are tons and tons of questions people have. Please subscribe. And once again, thanks for joining. My name is, I'm signing off, Dan Nandan with Prashanth Dubey. Have a good afternoon and good night for folks in India. Thank you.